Please be seated. The sitting is open. The court meets today and will meet in the coming days to hear the oral arguments of the parties on the preliminary objections raised by the respondent in the case concerning application of the International Convention on the Elimination of all Forms of Racial Discrimination, Armenia versus Azerbaijan. This morning, the court will hear the first round of oral argument of the Republic of Azerbaijan. I recall that since the court included upon the bench no judge of the nationality of either party, each party proceeded to exercise the right conferred upon it by Article 31 of the statute to choose a judge ad hoc to sit in the case. The Republic of Armenia chose Professor Yves Daudet, and the Republic of Azerbaijan initially chose Judge Kenneth Keith, both of whom were duly installed as judges ad hoc on the 14th of October 2021 during the phase of the present case that was devoted to a request for the indication of provisional measures submitted by Armenia. Following Judge Keith's resignation on the 21st of April 2023, Azerbaijan chose Judge Koroma, who was duly installed as judge ad hoc on the 20th of June 2023. I shall now recall the principal steps of the procedure in the present case. On the 16th of September 2021, Armenia filed in the registry of the court an application instituting proceedings against Azerbaijan concerning alleged violations of the International Convention on the Elimination of all forms of racial discrimination. I shall now refer to this convention as CERD. To found the jurisdiction of the court, Armenia invokes Article 36, paragraph 1 of the statute of the court and Article 22 of CERD. The application also contained a request for the indication of provisional measures pursuant to Article 41 of the statute and Articles 73, 74, and 75 of the Rules of Court. By an order of the 7th of December 2021, the court, having heard the parties, indicated certain provisional measures. By an order dated 21st of January 2022, the court fixed 23rd of January 2023 and 23rd of January 2024 as the respective time limits for the filing of a memorial by Armenia and a counter-memorial by Azerbaijan. The memorial was filed within the time limit thus prescribed. By a letter dated 16th of September 2022, Armenia, referring to Article 76 of the Rules of Court, requested the modification of the first provisional measure set out in the court's order of the 7th of December 2021. By an order dated 12th of October 2022, the court found that the circumstances as they then presented themselves to the court were not such as to require the exercise of its power to modify the measures indicated in the order of the 7th of December 2021. By a letter dated 28th of December 2022, Armenia, referring to Article 41 of the statute and Article 73 of the Rules of Court, filed a new request for the indication of provisional measures. And by a letter dated 26th of January 2023, it communicated to the court the text of a further provisional measure sought. By an order of the 22nd of February 2023, the court, having heard the parties, indicated a provisional measure. On the 21st of April 2023, within the time limit prescribed by Article 79 bis, paragraph 1 of the Rules of Court, Azerbaijan raised preliminary objections to the jurisdiction of the court and the admissibility of certain claims contained in the application. Consequently, by an order of the 25th of April 2023, the Court, noting that, by virtue of Article 79 bis paragraph 3 of the Rules of Court, the proceedings on the merits were suspended, and taking account of Practice Direction 5, fixed 21st of August 2023 as the time limit within which Armenia could present a written statement of its observations and submissions on the preliminary objections raised by Azerbaijan. The written statement was filed within the time limit thus fixed. By a letter dated 12th of May 2023, Armenia, referring to Article 76 of the Rules of Court, requested the modification of the Court's order of 22nd of February 2023. By an order dated 6th of July 2023, the Court found that the circumstances, as they then presented themselves to the Court, were not such as to require the exercise of its power to modify the measures indicated in the order of the 22nd of February 2023, indicating a provisional measure. On the 28th of September 2023, Armenia, referring to Article 41 of the statute and to Article 73 of the Rules of Court, submitted a new request for the indication of provisional measures. By an order dated 17th of November 2023, the Court, having heard the parties, indicated certain provisional measures and directed the Republic of Azerbaijan to submit a report to the Court on the steps taken to give effect to the provisional measures indicated within 8 weeks as from the date of the order. Azerbaijan accordingly submitted a report on the steps taken to give effect to that order on 12th of January 2024. Armenia provided comments on that report on the 26th of January 2024 within the time limit fixed for that purpose. By a letter dated 4th of March 2024, Azerbaijan reacted to those comments. After ascertaining the views of the parties, the Court decided, pursuant to Article 53, paragraph 2 of its rules, that copies of the preliminary objections of Azerbaijan and the written statement of Armenia on those objections, as redacted by the parties in order to protect personal or sensitive information, would be made accessible to the public on the opening of the oral proceedings. I would now like to welcome the delegations of the parties. I note the presence of the two agents, accompanied by members of their respective states' delegation. In accordance with the arrangements for the organization of the proceedings, which have been decided by the Court, the hearings will comprise a first and a second round of oral argument by the parties. The first round of oral argument will begin with the presentation of Azerbaijan today from 10 a.m. to 1 p.m. Tomorrow, Tuesday, 16th of April, Armenia will present its first round of oral argument from 10 a.m. to 1 p.m. The second round of oral argument of Azerbaijan will take place on Wednesday, 17th of April from 4:30 p.m. to 6 p.m. and Armenia will present its second round of oral argument on Friday, 19th of April from 10 a.m. to 11:30 a.m. In this first sitting, Azerbaijan may, if required, avail itself of a short extension beyond 1 p.m. in view of the time taken up by my introductory remarks.
You have the floor, Excellency.
Merci bien, Monsieur le Président, Mr. President, members of the Court. It is an honor to appear before you again and to do so on behalf of my country, the Republic of Azerbaijan. Azerbaijan considers its preliminary objections in this case imperative for the proper administration of international justice. Armenia's application misuses the third and tries to escape its obligation to attempt settlement of its dispute with Azerbaijan by way of negotiation before invoking the court's jurisdiction. This is the preliminary objections hearing in the first of two third cases between Azerbaijan and Armenia. However, when analyzed carefully, it is clear that the two cases are very different. Azerbaijan's third complaint, which will be the focus of next week, goes to the very heart of the Convention. It is centered upon ethnic cleansing and related systematic cultural erasure by Armenia of the Azerbaijani population and culture in the formerly occupied territories of Azerbaijan. These Azerbaijani territories were illegally invaded between 1991 and 1994 and subsequently occupied by Armenia for more than 30 years in breach of multiple resolutions of the United Nations Security Council. That invasion and subsequent occupation were driven by an overtly racist and nationalist ideology known as Tekahron. This racist ideology espouses the notion of a superior Armenian Aryan race, the racial inferiority of Azerbaijanis, and the unification of all ethnic Armenians within a single, mono-ethnic Armenian state, extending into the internationally recognized sovereign territories, not only of Azerbaijan, but also of other neighboring states. It was that overtly racist ideology which drove all of the Armenian misconduct that is the subject of Azerbaijan's third complaint. Azerbaijan's third complaint is also procedurally orthodox. It arises out of a timely invocation of the court's jurisdiction under Article 22 of the Convention, following a genuine attempt to negotiate until the other party walked away. By contrast, much of Armenia's third complaint, which is the focus of this week, does not concern the Convention at all. It concerns the military conflicts connected with Armenia's illegal occupation of almost 1/5 of Azerbaijan's land territory from the early 1990s and the subsequent liberation of that territory by Azerbaijani forces. Armenia's third complaint includes allegations of serious mistreatment of Armenians, including Armenian soldiers, POWs, and civilians, in connection with those conflicts. And it includes associated allegations of arbitrary detention and enforced disappearance of Armenians. In short, Armenia's third complaint includes a kaleidoscope of grievances arising in connection with those military conflicts. Such issues do not lend themselves to the court's jurisdiction under the cert. This is Azerbaijan's ratione materiae objection, on which I will elaborate shortly. Additionally, the entirety of Armenia's third complaint suffers from a fatal procedural flaw. Namely, to the extent that its complaint does arise out of a dispute between Armenia and Azerbaijan with respect to the interpretation or application of cert, Armenia's invocation of the court's jurisdiction under Article 22 was premature. That is because Armenia failed to engage in negotiations with Azerbaijan in an attempt to settle that dispute, and failed to pursue, as far as possible, the limited discussions that did take place. From the outset, Armenia had its sights firmly set on commencing these proceedings before the court and using the fact of these proceedings to wage a public media campaign against Azerbaijan. This is Azerbaijan's objection that Armenia has failed to comply with the negotiation precondition required by Article 22 of CERT, on which I will also elaborate shortly. An overriding explanation for Armenia's broadly framed CERT complaint is the limited scope of the compromissory clause at Article 2 of CERT. Armenia cannot resort to international adjudication with respect to its allegations of international humanitarian law breaches, arbitrary detention, and enforced disappearance. Thus, it has been driven to shoehorn those complaints, which properly analyzed contain no discriminatory elements within its third application. This preliminary objection phase provides an opportunity for the court to define parameters for its substantive third jurisdiction, both in respect of the military conflicts between Armenia and Azerbaijan and with respect to other conflicts around the world. This would be especially timely, given the growing tendency to misuse CERT in order to bring within the preview of this court ever more wide-ranging disputes. I will make some further remarks with respect to each of Azerbaijan's preliminary objections before handing over to members of Azerbaijan's council team who will lead you through the details. As I have mentioned, and as elaborated at paragraph 71 of Azerbaijan's preliminary objections, dated 21 April 2023, Azerbaijan raises two preliminary objections with respect to Armenia's third complaint. The first is that Armenia's complaint should be dismissed in its entirety due to Armenia's failure to comply with the negotiation precondition at Article 22 of CERT. Azerbaijan views that precondition as a solemn obligation of all CERT parties and as a critical precursor to CERT proceedings before the court. Consequently, Azerbaijan approached the negotiations with respect to Armenia's CERT complaints seriously and with a view to settling the CERT disputes. It is important for the court to appreciate the context here. Prior to Azerbaijan's attempt to negotiate the CERT disputes, Azerbaijani and Armenian representatives had not met for 30 years. As Professor Talman will explain, the exercise of setting even the basic framework for the negotiations to come took many months. There followed just two short online meetings of any substance, lasting a few hours each, before Armenia filed its application at the court. To say the least, this came as a surprise to Azerbaijan. There had been no genuine negotiation process before Armenia filed its complaint. The result is that the legal requirements for the invocation of the court's jurisdiction under Article 22 were not met. Armenia filed its application before even allowing a third meeting to discuss the parties' positions. Having received Azerbaijan's opening positions, Armenia simply broke off the discussions on 15 September 2021 and filed its pre-prepared application the very next day. In Azerbaijan's submission, to declare the negotiations precondition in Article 22 met in such circumstances would be to render that precondition devoid of meaning. Azerbaijan requests that the court use this opportunity to emphasize the importance of compliance with applicable negotiation requirements before invoking the court's jurisdiction. Azerbaijan's second preliminary objection is that even if the negotiation precondition is met, several elements of Armenia's application fall beyond the material jurisdiction of the court under Article 22 of CERT, because they are not capable of constituting racial discrimination within the meaning of CERT. Specifically, Armenia's complaints about the alleged murder, torture, and inhumane treatment of Armenians during the armed conflict, the alleged arbitrary detention of Armenians, and the alleged enforced disappearance of Armenians all fall beyond the parameters of a CERT complaint. Rather, they engage issues of international humanitarian law and other norms of international human rights law that are clearly not subject to the court's jurisdiction under the CERT. There is one exception. As indicated in my letter to the court of 5 April 2024, in its written observations, Armenia belatedly particularized some of its allegations of mistreatment with respect to Armenian civilians during the armed conflict, with reference to specific evidence purporting to indicate misconduct that is capable of falling within CERT. Now, as a responsible litigant, and in the interest of the court's efficient conduct of this proceeding, Azerbaijan has decided to withdraw its ratione materiae objection with respect to any of those adequately particularized allegations. Mr. Wordsworth will pick up this issue further in his speech today. For now, I would simply note that while it accepts that the court has jurisdiction over those exceptional allegations, Azerbaijan is certain that it will defeat them at any merit stage. In its formal submissions, at page 750 of its memorial, Armenia tries to dress up the relevant elements of its application as CERT complaints by simply adding the adjective discriminatory before each of its allegations, and emphasizing that the allegations concerned ethnic Armenians. You can see it on your screen. But simply adding these words to describe allegations that engage other norms of public international law without any accompanying specific evidence of racial discrimination is not sufficient to make those allegations capable of falling within the CERT. Armenia had to do more. Two further points warrant attention before I hand over to Professor Tolman. First, Azerbaijan's ratione materiae objection concerns only those aspects of Armenia's CERT complaint that fall beyond the subject matter of the Convention. It is not aimed at excluding the entirety of Armenia's CERT complaint from scrutiny by the court at this preliminary stage, at any merit stage, excuse me. Thus, Azerbaijan has raised no objection at this preliminary stage with respect to a number of Armenia's CERT complaints, including those connected with hate speech and alleged failures to take effective measures to combat racial discrimination. What is at stake here is the scope of the court's jurisdiction under Article 22 of CERT. In Azerbaijan's submission, the court can, and if it rejects Azerbaijan's first preliminary objection, then it should, building on the logic of its recent judgments, define the limits of its jurisdiction under the CERT. Second, while they fall beyond the court's substantive jurisdiction under CERT, Azerbaijan does not in any way condone alleged violations of international humanitarian law and other international human rights norms. On the contrary, Azerbaijan takes such allegations very seriously. The record shows that, unlike Armenia, Azerbaijan has not shied from convicting its own nationals of appropriate crimes where the allegations have been proven through judicial process. Of the dozens of Armenian POWs and other detainees taken during the Second Karabakh War and its aftermath, all the POWs and most of the detainees have been repatriated to Armenia. The rest are still incarcerated because they either have been convicted of serious crimes, including mercenarism, torture, and murder, or are currently being prosecuted for war crimes, terrorism, or separatism. In other words, the ongoing detention has nothing to do with racial discrimination. Similarly, Armenia's allegations concerning enforced disappearance of Armenians have nothing to do with racial discrimination. But Azerbaijan takes them seriously and has been working in cooperation with Armenia to ensure clarity, transparency, and mutual trust in the search for missing persons from both sides. Mr. President, members of the Court, that concludes my opening remarks. Azerbaijan's distinguished counsel will now address each of the preliminary objections raised by Azerbaijan. First, Professor Talman will address you on Azerbaijan's objection relating to Armenia's failure to comply with the negotiation requirement under Article 22 of CERT. Second, Mr. Wordsworth will address Azerbaijan's ratione materiae objection, with particular focus on Armenia's complaints about the alleged murder, torture, and inhumane treatment of Armenians during the armed conflict. Third, Professor Boisson de Chazourne will address you on Azerbaijan's ratione materiae objection related to the alleged arbitrary detention and enforced disappearance of Armenians. Thank you, Mr. President, honorable members of the Court, for the privilege of appearing before you. I now kindly ask you, Mr. President, to invite Professor Talman to address the Court.
I thank the agent of Azerbaijan for his statement. I now invite Professor Talman to take the floor. You have the floor, sir.
Monsieur le Président, Madam Vice President, distinguished members of the Court, it is an honor to appear before you. My task today is to present Azerbaijan's first preliminary objection that the application should be dismissed because Armenia failed to comply with the negotiation precondition in Article 22 of CERT. Under Article 22, a dispute may be referred to the Court only if it is not settled by negotiation or by the procedures expressly provided for in this Convention. The two threshold requirements for the Court's jurisdiction, negotiations and Convention procedures, are alternative and not cumulative. Armenia does not contend that its dispute with Azerbaijan was submitted to procedures expressly provided for in the Convention. The crucial question for the Court's jurisdiction, therefore, is whether the dispute is one that is not settled by negotiation. Mr. President, members of the Court, the question of whether the negotiation precondition under Article 22 is fulfilled has not yet been decided. In your order of 7th December 2021 on provisional measures, the Court observed that it appears that the dispute between the parties had not been settled by negotiation. No definite finding was made at the time. At the stage of the proceedings, the Court needed only decide whether prima facie it had jurisdiction. The prima facie threshold is, of course, substantively lower than that which the Court must now apply in order to establish definitely whether or not it has jurisdiction over Armenia's third complaint. Indeed, the Court expressly reaffirmed that its decision in no way prejudges the question of jurisdiction of the Court. The Court may recall that in Georgia versus Russia, it also found at the provisional measures stage that the dispute had not been resolved by negotiation and that prima facie it had jurisdiction. This did not prevent the Court from ruling later at the preliminary objection stage that the parties did not engage in negotiations and that consequently it had no jurisdiction over Georgia's third complaint. The same is true in the present case. Armenia has not fulfilled the negotiation requirement, and there is thus no jurisdiction under Article 22 of CERT. In Georgia versus Russia, the Court set out the conditions that must be fulfilled in order to meet the negotiation requirement in Article 22. First, there must have been negotiations between the parties, or at least a genuine attempt at negotiations by the applicant. Second, if negotiations were conducted or the applicant genuinely attempted to engage in negotiations, the negotiations must have been pursued as far as possible with a view to settling the dispute. Neither of these conditions has been fulfilled by Armenia in the present case. Mr. President, let me start with the first condition. Whether there have been negotiations between the parties, or at least a genuine attempt at negotiations by the applicant, this depends on what constitutes negotiations in terms of Article 22. In determining what constitutes negotiations, the Court observed that, I quote, "Negotiations are distinct from mere protests or disputations. Negotiations entail more than the plain opposition of legal views or interests between the two parties, or the existence of a series of accusations and rebuttals, or even the exchange of claims and directly opposed counterclaims." End of quote. Rather, the concept of negotiations requires that the parties engage in discussions with a view to resolving the dispute, or at least make a genuine attempt to do so. Whether discussions or contacts between the parties constitute negotiations depends upon the substance. The Court held that the subject matter of the discussions or contacts must relate to the substantive obligations under CERT. Compliance with the substantive obligations under CERT must be at the heart of the contacts or discussions for these to qualify as negotiations. It is not sufficient for there to be exchanges between the parties. These exchanges must concern the substantive obligations contained in the CERT, or, in other words, matters concerning the interpretation or application of CERT. This substantive requirement excludes pre-negotiations, negotiations about negotiations, from the concept of negotiations under Article 22. Pre-negotiations are distinct and prior to actual negotiations. They determine the location, procedural modalities, scope, and topics for discussion. Pre-negotiations are not about the substance of the dispute and thus do not qualify as negotiations in terms of Article 22 of CERT. In its Provisional Measures Order of 7 December 2021, the Court noted that the parties engaged in a significant number of written exchanges and meetings over a period of several months. The Court, however, also noted that these exchanges covered the procedural modalities, scope and topics of the negotiations. Such procedural or technical exchanges, according to the Court's own definition, do not qualify as negotiations. Armenia claims that for over 10 months it exchanged more than 40 pieces of correspondence with Azerbaijan and participated in 7 rounds of meetings in an effort to settle the dispute amicably. It further claims that the parties engaged in nearly a year of extensive negotiations. Mr. President, these statements are misleading. They confuse the parties' lengthy pre-negotiations with actual negotiations as required by Article 22. While Armenia meticulously lists every single piece of correspondence between the parties in its memorial, it does not say a single word about the content of these documents. A closer look at the content of these documents and the subject matters discussed at the online meetings between the parties paints a very different picture. Mr. President, members of the Court, let me take you through the exchanges between the parties one by one. The correspondence between the parties started on 22 November 2020. In a 2-page letter addressed to the Foreign Minister of Azerbaijan, the Minister of Foreign Affairs of Armenia alleged for the first time, in very general terms, that Azerbaijan, over the course of the past decades, had violated its obligations under multiple provisions of the Convention. Armenia also invited Azerbaijan to enter into negotiations for the purpose of addressing and remedying its violations. The letter provided a non-exhaustive list of 8 abstract actions through which the Convention had allegedly been violated, but did not contain any information on specific violations or any request for remedies. Azerbaijan's foreign minister responded on the 8th of December 2020, rejecting Armenia's assertions and listing on his part, by example, 7 general actions by which Armenia had violated its obligations under the Third. In that letter, Azerbaijan also indicated that it remained open to negotiating this matter with Azerbaijan. The 2 letters did not address any specific violations of the Convention, let alone link any of the actions to particular obligations under the Convention. In the Court's own words, such a written exchange of claims and directly opposed counterclaims may evidence the existence of a dispute, but it does not constitute attempts at negotiations between the parties. In fact, this exchange provided a prelude to the ensuing pre-negotiations. Over the next 7 months, from December 2020 to July 2021, the parties engaged in pre-negotiations, negotiations about negotiations, or talks about talks. 7 months of pre-negotiations may seem a long time. However, it must be remembered that the parties had not met bilaterally without a mediator for almost 30 years. The technical discussions thus served as confidence-building measures prior to commencement of negotiations related to Armenia's third complaint. Such pre-negotiations are a general feature of the relations between the parties. For example, on the 26th of May 2022, the Armenian Minister for Foreign Affairs stated with regard to possible peace negotiations between the parties, and I quote, "Armenia and Azerbaijan are still holding negotiations about negotiations." In their pre-negotiation correspondence and meetings, the parties focused on procedural modalities, scheduling timetables, scope and topics for the discussions to be held on the alleged violations of the Third, and the agenda for their meetings. For example, on the 22nd December 2020, Armenia suggested to start with the format and process of further negotiations. On the 3rd of March 2021, Armenia expressed its hope that, I quote, "the parties will continue approaching their initial procedural matters in the same constructive fashion with a view to promptly reaching agreement on the remaining open questions of modalities of further negotiations." Mr. President, members of the Court, as you can see on screen, it was only on the 3rd of May 2021 that the parties confirmed the 12-point agreed procedural modalities for their substantive discussions. However, this was not the end of the pre-negotiations. The parties continued to discuss the topics for their negotiations and the scheduling of the substantive negotiations. On the 31st of May 2021, the parties presented the topics which they wanted to address during the substantive negotiations. In its presentation on the scope of the negotiations, Armenia identified several topics which had not been included in the first list of alleged convention violations in its letter of 11th November 2020. The newly introduced topics included allegations of engagement in practices of ethnic cleansing, suppression of civil society organizations working towards reconciliation with Armenia, and failure to provide Armenians with equal treatment before tribunals and all other organs administering justice. None of these allegations could have been the subject of negotiations for the simple reason that none had been made before. The two-page list of Armenia's topics to be discussed at the substantive talks was phrased in very general terms and did not include any specific examples, facts, or evidence of alleged violations. Armenia also stated that it intended to discuss the remedies at the talks, but did not specify any remedies in connection with the alleged third violations. Without any of those specifics, a substantive discussion of alleged third violations was still impossible at that stage of the pre-negotiations. That there were no substantive negotiations has also been confirmed by Armenia on no less than 4 occasions. On the 30th of April 2021, Armenia noted the length of time, I quote, without any substantive discussions having been held. On the 22nd of May 2021, Armenia stated that it expects no further delay to the commencement of substantive negotiations on its claims under the third. On 3rd of June 2021, it noted that substantive negotiations still have yet to begin. And on the 22nd of June 2021, it stated that it was ready to commence meaningful substantive negotiations. Armenia seems to take the view that substantive negotiations finally started on 15-16 July 2021. In its letter to Azerbaijan, dated 9th July 2021, Armenia stated with regard to the proposed schedule of meetings that it trusted that this proposal would allow substantive negotiations to commence promptly on 15th July. According to the schedule agreed between the parties, as you can see on the screen, at the meeting on 15-16 July 2021, Armenia presented its claims and requested remedies. This was the first time that Armenia presented any specific allegations, set out its legal position, and identified the remedies it was requesting. At the meeting on 31st of August 2021, Armenia presented its replies. The two meetings were thus devoted solely to the oral presentation of the claims and replies. There was no discussion of those claims and replies at these meetings or in subsequent correspondence. In fact, no discussion was foreseen at that stage. The parties had expressly agreed to schedule the presentation of claims and replies some 6 weeks apart in order to allow them to prepare their replies. By 15 September 2021, which is labeled on the screen as the end, when Armenia informed Azerbaijan that it considered the negotiations to have failed, all the parties had done was raise allegations of third violations and present their opposing positions on the facts and the law. In the words of the court, the parties had exchanged a series of accusations and rebuttals. What they had not done was engage in any discussion with a view to resolving the dispute. Azerbaijan therefore submits that prior to 16 September 2021, when Armenia instituted the present proceedings, there had been no negotiations. In fact, negotiations in terms of Article 22 of CERD had not even started. Mr. President, members of the court, there were not only no negotiations, but Armenia never made a genuine attempt at such negotiations. It never attempted to engage in any meaningful discussion with Azerbaijan with a view to resolving the dispute. It is clear from the evidence that from the outset, Armenia's only aim was to bring its allegations against Azerbaijan before this court. This is confirmed by its very first diplomatic note of 11 November 2020, when it invited Azerbaijan to enter into negotiations for the purpose of addressing and remedying the alleged third violations. This invitation was immediately followed by an ultimatum to respond and a threat of legal action. Armenia stated, and I quote, "Should Azerbaijan reject this invitation or fail to respond to it within no more than a month from the date of receipt of this letter, or should any purported negotiations become futile, Armenia reserves the right to seek to settle the dispute in accordance with the procedure described under Article 22 of the Convention." End of quote. Before negotiations could even start, Armenia already spoke of purported negotiations and their futility. It implicitly threatened that if it did not get its way, it would simply declare the futility of the negotiations and take the dispute to the court. But discussions with a view to resolving the dispute cannot be based on threats, but require openness to the other party's position, flexibility, and the ability to compromise, none of which has been shown by Armenia. Proceedings before this court were at the forefront of Armenia's mind throughout the pre-negotiations. Thus, it was of the greatest importance to Armenia to be able to use material from the negotiations to prove that the negotiations had failed. For 3 weeks, the pre-negotiations were solely concerned with Armenia's wish to include in the agreed procedural modalities a passage that would allow Armenia to prove as a matter of fact that negotiations had in fact failed. Before negotiations had even started, Armenia was already more concerned with their failure than with making them a success. This is not what a genuine attempt at negotiations looks like. Mr. President, throughout the pre-negotiations, Armenia adopted a totally unrealistic and unreasonable position with regard to the time necessary for the substantive negotiations. Armenia accused Azerbaijan of multiple different violations of numerous third obligations, with underlying facts spanning, in Armenia's own words, past decades. The magnitude of the dispute is demonstrated by the fact that Armenia has now submitted to this court a 755-page memorial accompanied by 297 annexes totaling 1,220 pages. In these proceedings, Armenia requests the court to rule on 10 alleged breaches involving numerous third provisions and to provide at least 10 different remedies. Mr. President, members of the court, how many days would you allocate for negotiating such a substantial dispute? Probably months, if not years. Armenia, on the other hand, initially suggested just 1 day, with a second day held in reserve for possible further discussion on Armenia's claims. While Azerbaijan pointed out on numerous occasions that a meaningful discussion of the allegations requires more time, Armenia in the end only agreed to a schedule that allocated 2 days for the presentation of its claims and requested remedies, and gave Azerbaijan another 2 days to present its replies. 4 days in all. Armenia initially suggested that each day consists of 5 hours and 30 minutes of actual presentation time, which would have meant a total of 22 hours for both parties' presentations. In the end, I was told the actual time used for these 2 presentations was less than 7 hours. The allocation of 7 hours for the presentation of claims and replies cannot be considered a genuine attempt at negotiations with regard to settling a dispute of this magnitude. The present case may be contrasted with a third case between Ukraine and Russia, which was of similar magnitude. In that case, Ukraine sent 19 diplomatic notes to Russia, expressly referring to the rights and obligations under the Third and the alleged violations of the Convention, and providing Russia with extensive and detailed records of alleged acts of racial discrimination. During 3 rounds of face-to-face meetings, Ukraine engaged with Russia on the facts and circumstances of specific discriminatory acts and sought Russia's responses and explanations. Ukraine also provided responses to Russia's questions concerning specific incidents, both during the meetings and in follow-up diplomatic correspondence. It is against this background that the court observed that, I quote, "Negotiations between the parties lasted for approximately 2 years and included both diplomatic correspondence and face-to-face meetings, which, in the Court's view, and despite the lack of success in reaching a negotiated solution, indicates that a genuine attempt at negotiation was made by Ukraine." End of quote. There is no similar evidence of a genuine attempt at negotiation in the present case by Armenia. Mr. President, during the pre-negotiations, Armenia also paved the way for unilaterally declaring the negotiations to have become futile. While initially Armenia suggested that the parties jointly assess whether further negotiations are constructive in resolving the dispute, it later reserved for itself the right to assess if further negotiations might be constructive. In the end, it dropped any reference to such assessment. In particular, it did not agree to Azerbaijan's suggestion that after the September session, the parties shall mutually assess their progress and whether there exists a clear path forward to amicable settlement of all or parts of their claims. Such an approach cannot be considered a genuine attempt at good faith negotiations. On 15 September 2021, at the meeting that was actually reserved for the presentation of Armenia's replies to Azerbaijan's own cert claims, Armenia rejected Azerbaijan's proposals for remedies outright, without engaging with them. It simply unilaterally declared that the negotiations had failed and walked away. Again, not a genuine attempt at negotiations. Less than 24 hours after declaring that the negotiations had failed, Armenia submitted an 82-page application instituting proceedings against Azerbaijan for alleged violations of cert, accompanied by a request for the indication of provisional measures. The detailed application was accompanied by 62 annexes. 10 of these annexes were accompanied by certified translations, which had all been prepared between the 2nd and 13th of September 2021. Now, everyone familiar with cases before this court will understand that such an elaborate application requires several months of preparation. Work on these documents must have started well before Armenia even presented its claims to Azerbaijan on the 15th of July 2021. Armenia's conduct clearly shows that it never made a good faith attempt at settling the dispute by negotiations. It never gave negotiations a chance. It treated its exchanges with Azerbaijan as no more than a formality to go through in order to do what it had planned from the start: initiate proceedings before this court. Mr. President, members of the court, with no negotiations and no genuine attempt at negotiations, that basically is the end of Armenia's application. If the court should find, however, that a mere presentation of Armenia's claims on 15-16 July and the presentation of Azerbaijan's replies on the 30th, 31st of August were sufficient to constitute substantive negotiations, or that Armenia, despite of what has been said, made a genuine attempt at such negotiations, the court must decide whether Armenia pursued the negotiations as far as possible, with a view to settling the dispute. As the court held in Georgia versus Russia, to make this determination, it must ascertain whether the negotiations failed, became futile, or reached a deadlock before the application was submitted to the court. The court's inquiry into the sufficiency of negotiations is a question of fact to be considered in each case. It is not for Armenia simply to declare unilaterally that negotiations failed. Indeed, Armenia has not provided any evidence that it pursued the negotiations as far as possible with a view to settling the dispute. In past cases, the court has found that negotiations have failed or reached the point of futility or deadlock when the parties' basic positions had not subsequently evolved after several exchanges of diplomatic correspondence and/or meetings. In order to qualify as negotiations in terms of Article 22, these exchanges of diplomatic correspondence and meetings must, of course, refer to the substantive obligations underserved. Armenia and Azerbaijan set out their positions on 15, 16 July and 30th and 31st of August 2021, respectively. There were thus not several exchanges of diplomatic correspondence or several meetings, but just 2 meetings in which each side set out its position for the first time. Meetings with such a narrowly defined purpose cannot form the basis for finding that positions have not evolved or that no progress has been made in terms of substantive matters. It is difficult to see how Azerbaijan's position could have evolved and how progress in reaching common ground on substantive issues could have been made when the discussions were terminated by Armenia shortly after Azerbaijan had set out its position for the first time. A position can only evolve when it is given a chance to evolve. At the provisional measures stage, the court found that, based on information available then, it seems that the position of the parties remained unchanged and that their negotiations had reached an impasse. As I've already shown, the court is not bound by this finding. The finding is also incorrect. Progress on substantive matters was indeed made. In its reply to Armenia's claims and requested remedies, Azerbaijan did not rebuff the idea of remedies, but in the interest of resolving the dispute, submitted a proposal for joint actions. Several of the 13 actions proposed by Azerbaijan directly corresponded to the remedies requested by Armenia, which is demonstrated by the fact that they also correspond to the remedies Armenia now requests before this court. Mr. President, members of the court, let me give you just 3 examples of progress, albeit tentative, that has been made in just 2 exchanges. First, Armenia asked the court to order Azerbaijan to allow the safe and dignified return of displaced ethnic Armenians to their homes and places of origin. In its proposals, Azerbaijan had offered to facilitate the return of all refugees and internally displaced persons displaced by the conflict who desire to return to their homes. Second, Armenia asked the court to order Azerbaijan to guarantee the right of ethnic Armenians within its jurisdiction to equality before the law, notably in the enjoyment of the human rights and fundamental freedoms. In its proposals, Azerbaijan had offered to take steps to provide for the rights of everyone, regardless of ethnic origin, to equality before the law and the equal enjoyment of fundamental human rights. Third, Armenia asked the court to order Azerbaijan to adopt immediate and effective measures in the fields of education with a view to combating prejudices which lead to racial discrimination against ethnic Armenians. In its proposals, Azerbaijan had offered to assess educational materials and remove any anti-Armenian statements from textbooks and other materials used in schools. In addition, in response to Armenia's claims with regard to the military trophies park, Azerbaijan offered in its reply to acknowledge that the use of monikers to depict Armenian soldiers in the military trophies park has inflamed tensions between the two states, and to consider removing some monikers depicting Armenian soldiers and ensure that the park tour guides do not use inflammatory language inciting discrimination against Armenians. All these proposals by Azerbaijan show that the negotiations were not at an impasse or futile. They had just started. Azerbaijan expressly confirmed its willingness to discuss its proposals to resolve Armenia's claims and to consider any other reasonable proposal put forward by Armenia. However, rather than putting forward any proposals, Armenia just walked away. That concrete results could be achieved when the parties constructively engaged was shown by the exchange of Armenian personnel for information on a portion of landmines planted by Armenia in Azerbaijan's liberated territories. The same could have been the case with regard to the third complaints. Armenia did not engage with Azerbaijan's proposals for remedies, but summarily rejected them, apparently because Azerbaijan did not concede Armenia's claims outright. Negotiations, however, do not mean that one party simply submits to the demands of the other. Armenia also took exception to Azerbaijan's proposals being made on a no prejudice basis. But diplomatic negotiations are often conducted on a no prejudice basis in order to facilitate the free exchange of proposals. During the pre-negotiations, Azerbaijan had expressly suggested including a no prejudice clause in the agreed procedural modalities. Armenia's reason for unilaterally terminating the negotiations thus cannot be considered valid. There is no question of the negotiations failing due to a lack of progress on substantive matters. the only reason why negotiations were not pursued as far as possible is Armenia's unwillingness to do so. As negotiations have not been exhausted, the precondition of negotiation is thus not met. Let me conclude. According to the Court's own definition of negotiations in terms of Article 22, the parties never conducted negotiations, and Armenia also never made a genuine attempt at such negotiations. Even if it did, by unilaterally breaking off the negotiations when they had only just begun, Armenia did not pursue these negotiations as far as possible. If Armenia's conduct in this case indeed sufficed to meet the requirement of negotiations, this procedural precondition would not just be downgraded to a mere formality, it would become a farce with far-reaching consequences for future cert cases more generally. For these reasons, the Court should uphold Azerbaijan's first preliminary objection and dismiss Armenia's application for lack of jurisdiction under Article 22 of the cert. That brings me to the end of my presentation. I thank the Court for its kind attention. Mr. President, it might now be a convenient time for a short break. Otherwise, may I ask you to call on Mr. Wordsworth to present Azerbaijan's second preliminary objection. Thank you.
I thank Professor Talman for his statement. Before I invite the next speaker to take the floor, the Court will observe a 10-minute break. The sitting is suspended.